moving on, amidst the ongoing and escalating tensions between the executive and judiciary, President Droupadi Murmu has fired 14 pinpointed questions at the Supreme Court. This is in response to the top court's judgment last month, where it had set timelines for the president and governors to decide on a bill passed by a state assembly. The questions have been raised under Article 143 that empowers the president to consult with the Supreme Court on matters that involve constitutional or public importance. The reference, made under the president's power to seek the court's advisory opinion, questions whether such timelines prescribed by the judiciary can bind constitutional authorities like the president or the governors. Now let's take you through the 14 questions that have been raised by President Murmu. The first question that was asked is, what options does a governor have under Article 200? The second question is, must the governor act solely on ministerial advice? The next question, can governor's discretion be scrutinized judicially? Does Article 361 fully shield governor's decisions? Can courts impose timelines for governors to act? Can the president's discretion be judicially reviewed? Is president bound by judicially prescribed timelines? Eighth question being, does president have to seek opinion of the Supreme Court when a bill is reserved? Can courts act before a bill becomes a law? And does Article 142 allow overriding governor or president's decisions? Then there were questions like, can a bill become law without governor's assent? Should interpretation questions go to a constitution bench first? And can Article 142 contradict laws or constitution itself? And the final question, are center-state disputes resolvable beyond Article 131? Now this follows Supreme Court's April 8th ruling in the Tamil Nadu government versus the governor case. In that verdict, the court had held that inordinate delays by governors in dealing with bills passed by state legislature were unconstitutional. The court laid down that governors must act on bills within 3 months, and that if the bill is returned or repassed, assent must be granted within 1 month. The ruling also applied a 3-month limit to the president on bills reserved for her consideration. The Supreme Court is expected to set up a constitution bench to examine the questions that have been posed today. Though its opinion will be advisory and not binding, this is going to carry immense legal and constitutional weight.
रेफरेंस में मैं आपको बताना चाहूँगा, दो अनोखी चीज़ें हैं। पहली चीज़ तो हमें ये समझना चाहिए कि सुप्रीम कोर्ट के राष्ट्रपति महोदय क्या मांग रही हैं। वो कह रही हैं दो चीज़ें। पहला कि सुप्रीम कोर्ट की 142 की पावर क्या है, ये चीज़ बड़ी गौर से समझिए। वो पूछ रहे हैं कि सुप्रीम कोर्ट 142 में कहाँ तक जा सकती है। दूसरी चीज़ वो ये कह रहे हैं कि गवर्नर किस तरह एक डिसीजन ले सकते हैं कि कोई बिल आए तो उस पे वो क्या निर्णय ले सकते हैं। गवर्नर को काउंसिल ऑफ मिनिस्टर्स की बात सुननी है या उसके आगे जाना है। तो ये दो चीजें जो आई हैं बहुत जरूरी हैं, जिसको हमें समझना पड़ेगा।
The latest in